after the presentation. But public records law involves three main statutes, Chapter 6610, which mostly defines what a records access officer is. We have our main records access officer is our town clerk, Peggy Wang. I believe that the Board of Selectmen has also appointed Tim Goddard as a records access officer for Selectmen's business, and Chief Fisher as a records access officer for police business. So they would likely be the three that would be helping us process our records requests, although they can come into anyone. So again, 6610 really tells us a lot about what a records access officer does and how they do their job. Chapter 4, Section 7 is our definitions and exemptions. And this will be the only time I'm going to read you a definition, but I'm going to read you a definition of public record. And that definition is all books, papers, maps, photographs, recorded tapes, financial statements, statistical tabulations, or other documentary material or data, regardless of physical form or characteristic, made or received by a governmental entity or employee, I would add, unless such material or data falls within one or more of the exemptions. Okay, so the safe bet is to assume that the record requested, or the record you're wondering about, whether or not that is a public record, it likely is. And then we'll get into more detail as we go along. Okay, so our records access officers. So they're here to manage record requests, to file fee petitions on our behalf if we need them, to publish records guidelines. So if there's, if there's certain ways that we like to do things, they can publish guidelines to that effect, and that their contact information should be on the website. So I'm going to get into how to manage records requests and file fee petitions as we go along. And I don't know if any of you have ever dealt with significant records requests, but it can get costly quickly. Okay, so kind of more general information. So the state is required to have these 4 things available on their website: final opinions, annual reports, minutes of open meetings, and agency budgets. So while a municipality is not required to have these things on their website, they're strongly encouraged to. And I read that to mean that while we're not required to currently, we should be prepared to have these things on our website in the near future. So final opinions, again, it's a state term, but in our vernacular, I think that would be significant land use decisions should be available on the website. Annual reports, we know what the annual report is. Minutes of our meetings, we know what those are. And then our annual budget should also be available. So again, we're not required to, but it's we should be aspiring to get that stuff on our website. Okay, the form of a request. So we get our request for a public record. It can be written or oral. So the first thing to understand is if someone asks you for a record, you cannot require them to put their request in writing. We are allowed, or people are allowed to submit oral requests. The key difference is that an oral request cannot be appealed, so that if they're dissatisfied with what we provide them, they have no avenue of appeal. It ends there. Okay, so this is, again, every record that is made or received by a governmental entity or employee, regardless of form, is presumed to be a public record. So now here's where I want to give you an alert about your personal email. It is always my advice that if you're serving on a board or committee for the town, that you create a separate email address. John Doe Carlisle Planning Board at gmail.com, or any any kind of version of that, because the communications you send back and forth regarding town business are public records. And I don't want you to get in the situation where, you know, it's an ugly situation and a lawsuit is filed and they want access to your public records. And if all your records are within your personal email, then you may need to give your personal email or give another party access to search your personal email. So the best practice is to make sure all your public records or all your public emails are in a separate account.
All right, I have a question.
Okay.
I have a town account, but I hate having to look at two email servers. So I have everything from my town account forwarded to my personal account so I can look at everything in one place.
Okay.
Well, and it's not really, yeah, I guess it's, yeah.
So Kate, that's fine. I guess to me, the watch out here is when you're replying, make sure that you're replying from the town account and not your personal account.
Actually, my mailer allows me to do that. If it comes in on the exchange and I answer it, it goes out on that server.
Perfect.
Okay.
Then you're creating a strong record.
Okay, good. Just
Okay.
Tom,
Yeah.
we had a question about cell phones and text messages.
So text messages technically are considered public records. There is some decisions out of the state that have required municipal employees to produce their text messages. And I will say this is one of those difficult parts where I think the technology is ahead of the state, because, you know, we all know that texting is easy, and saving text is not necessarily easy, or is not necessarily obvious how you save your texts and, you know, maybe remove them from your phone. I think most people just delete and move on. So you should be aware that text messaging is a public record. And my advice is, if you're going to text, keep it to the simple stuff, because we know from the Secretary of State that if it's a question about, you know, when the meeting is, where the meeting is, what are we going to put on the agenda, that kind of basic stuff, you're allowed to delete those texts as soon as the meeting is over. So, you know, if there's a very, if there's a kind of a procedural time element to your text, and that time has passed and it's no longer really a record of interest, you're allowed to delete it. So I would say, if you're gonna text, stick to those kind of simple things so that you don't get in trouble if you delete after the fact.
Does that same apply to email, Tom?
Yes, it does apply to email. As long as it's again, as long as it's just when the meeting is, where the meeting is, you know, what are we going to put on the agenda? Once that meeting has occurred, and I would say you've approved the minutes, I don't think you need to save that record anymore.
Thank you.
Okay, so you recall that in the definition I just read, you know, everything in the universe is a public record unless it falls under the one of the exemptions. And this is an important distinction, particularly for records access officers. I think it helps for others to know it, but if you're involved in a records request, you do want to understand this. So there's two types of exemptions that the state allows. One is discretionary and one is non-discretionary. So non-discretionary, CORI information, FERPA information. FERPA is an educational statute. HIPAA information, or Chapter 93H information. Chapter 93H is any information that relates to your Social Security number in combination with a bank account, address, name, so that people could access, maybe some of your financial information. So any record that we produce that has any CORI, FERPA, HIPAA, or Chapter 93 information, that information must be redacted. We do not have an option. We must redact that information. The discretionary information is privacy information, and privacy is pretty broad. And to me, the best definition of privacy is it's likely more damaging to the person if that information were to get out than it is helpful to the public if that information were to get out. You know, so if you're talking about someone's illness or a specific problem someone's having, you know, kind of individual things like that, that's privacy information, and we don't need to release that. But again, it's at our discretion. So when we get records requests, we have to consider whether any of these things, privacy, personnel files, home addresses, and kind of things like that, we have to decide whether or not we want to redact that information from the public record. And that leads us to a fairly complicated process. So let me explain how the process works. And kind of overarching everything I say with the public records law and the open meeting law is the idea that transparency trumps privacy. I mean, trumps efficiency, so that the state considered both and really threw efficiency right out the door. They're not interested in allowing you to do your job efficiently. They are most concerned that you do it transparently. So getting back to the public records request. So when we get a request, these are kind of our essentials. We have 10 business days to produce or respond. We have to produce them in searchable, machine readable format. So that's a PDF that's searchable, or in another format if we have access to it and it's requested. And if we have the version online, we can just direct them to the online version. So if someone's asking for meeting minutes from 2 years ago, you can just say all meeting minutes are on the town's website and you can access them there. Okay, so I'm just going to take you through. This is just going to take a few minutes, but again, I think it's important that everyone understand how this works. I'm going to take you through the process for responding to a public records request. So say we get a request for every email between Tim Goddard and Charlie Baker related to COVID, and there are 2,000 of them. So the first thing we want to do is identify those records that are and are not within the town's control. So if they're not in our control, we don't need to produce them. Only though we don't have to chase them, we only have to produce what we have. We then need to consider what documents we want to withhold, whether it could be Corey information, it could be one of those non-discretionary reasons or a discretionary reason. So once we do that, and we want to do that in fairly short order, so we've identified the number of documents and whether or not we think there's sensitive information in them. We now go back to the requester and say, you know, your request produced 1,000 documents and there's a fair amount of sensitive information. Would you like to modify your request? Because maybe you only want the email between Tim and the governor from June 25th, 2019. So they have that opportunity. Sometimes they take it, sometimes they don't. If they don't, we want to produce a fee estimate. So we're going to tell them how much we think it's going to cost us to produce these records, and we can require that they pay first. But all this needs to happen within the 10 business days. So if we miss those 10 business days, we can't issue a fee estimate anymore. And throughout this process and every part of the process, we need to let the requester know that they have the right to appeal to the Secretary of State's office. Finally, we can tell them if this is a big request and we need more time, we can say, we're going to take up to 15 additional business days to produce your request. Okay, so that's our process. So for our fee estimate, we want to estimate the time it's going to take us to search records. And so the state believes that paper records are much more difficult to search than electronic records. So that we're doing a paper search, you know, that's the time it takes you to pull the record, go through the record, segregate those records, make copies, return them to their folder, and put them back. That's all that money can be charged by us. Electronic, obviously, the state thinks we can do that much quicker. So while we can charge for that, we can't charge much because they assume that the search processes are substantial and shouldn't take much time. We're allowed to charge $25 or the hourly wage of the lowest paid employee who can do that, whichever is less. So chances are we're going to lose a little money on that one. We're allowed to charge 5 cents per page for copying or the actual cost. But the actual cost is expected not to be more than 5 cents per page. This 2 hours for free doesn't affect Carlisle. It's for towns of over 20,000. So you start from day one or hour one in being able to charge fees. Okay, a fee petition, and this is again is important, this is particularly if we get a big request. We're allowed to seek a fee petition or petition for additional fees from the Secretary of State. What this means is that within those 10 business days, we need to file our fee petition. And so as a, for instance, say it's, you know, there's a lot of legally sensitive information in there and we want an attorney to review. And we know that an attorney charges more than $25 an hour. So we can say, you know, we believe there's a lot of sensitive information. It's going to require an attorney to review it. And we would like to have the opportunity to charge for those fees. We're finding that these fee petitions are granted more often than not. And so we want to keep that in mind. But again, unless we act quickly on these records requests, we're going to get left out in the cold. So if we're filing our fee petition after 10 days, it's going to be disallowed. So again, when you don't ignore that records request when you get it. You know, if you're a board member and someone's filing or sends it to you, make sure you're getting it to Peggy or Tim or both, just so we get a records access officer's eyes on that request. Okay, this takes a little bit of thought. And so I think if you look at it, you know, kind of in your free time, you can make more sense of it. But I'll just go through the process where it says, so we're starting here. I don't know if you can see my pointer, but we get our records requests. The first things we want to do is determine the due date and the number of responsive records. Now, if we want to charge a fee estimate, we can charge a fee estimate, and we can include in that estimate our search and segregation time and the redaction of non-discretionary. So we issue our fee estimate. It's going to cost $150. We get our $150. We produce the records. That's one way to go. Second way to go is to seek that modification. And I always encourage, and the state will encourage you to seek a modification. Sometimes people don't know that they're asking for, you know, 2,000 documents. So it's always important to go back to them and say, your request produced a number of hits. Maybe we can tailor it down. All right, so if we don't get the modification or a satisfactory modification, here's our options. We go up to petition the supervisor to charge more than $25 an hour to do some, you know, legal level redactions. Once they approve that fee petition, we send it back to the requester, and they can either pay it or not. We decide we can live within our $25 an hour. We issue a fee estimate, which is search and segregate and non-discretionary redactions, get our money, produce the records. And then of course, the bottom one is just produce the records or get a modification and produce the records. I know that's a lot of information. But I think if you get the request and it's a big one, the chart makes more sense. Okay, so it's important to understand that the requester has appeal rights, and if we're not behaving properly, we're going to suffer if they appeal. So if we fail to comply with the requirements of the public records, they can file an administrative appeal with the supervisor of records. So say someone requests records and we just ignore it, miss it, whatever. They'll go to the supervisor of records. The supervisor of records will usually say, you know, you get those out ASAP. They could also initiate a civil action to enforce the law. This is relatively new in the law, but I have not yet seen it. However, if they do initiate a civil action, and if they win in the lawsuit, the law creates a presumption that the requester is entitled to attorney's fees and costs. So again, we need to be aware that we don't necessarily want them to go to court. And if they do, and we think we're going to lose, we could pay attorney's fees. So again, just best practice, you know, get on the records requests early, be efficient, and you know, we can protect ourselves. If we don't, we're going to find ourselves in trouble. And then finally, the Attorney General has the power to impose up to $5,000 in fines if they think we're really behaving badly. And I have seen fines imposed. I haven't seen significant fines imposed, but you know, they will issue a few wrist slaps, but you know, come the third or fourth time when they think you're ignoring them, the penalties are going to get a little stiffer. Okay, so that concludes public records law. Before I move on to open meeting law, any other questions?
I've got a few questions, Tom, that were submitted through the chat function.
Okay, want to
If I
read them
could
to
just-
me?
Sure, sure. Is there a time limit regarding to the retention of personal emails that refer to town business? What should someone expect regarding their personal emails that may be related to town business? Do they have to preserve them in perpetuity, or?
They do, but we can, so the way this works is you need to maintain the public record until the state gives us permission to destroy the public record. And you know, Tim, this actually might be a good project for right after town meeting, is to understand how many records people are holding and to petition the custodian of records to allow us to destroy certain records. So it's a process to destroy it, but there is a process and it does work.
Okay. Another question referring to, you referred to the term in control, records that we are in control of. What does that mean specifically? Are there records that we might have that we're not in control of?
No, so it really means if, so I guess using a permit process, you know, so the applicant emails us, we have control of those records, they're on our system, we can produce them. The applicant, you know, the applicant's engineer emails us, we have those emails on our email system, we have control of them, we can produce them. Any email between say the applicant and his engineer that he didn't copy us on, we don't have control of. So someone may say, I want every email that the developer sent to you, that his engineer sent to you, and that the engineer and the developer sent to each other. Well, we can do 2 of those 3, but if we don't have copies of those emails between the applicant and his engineer, the developer and his engineer, we're not required to ask for them. You know, and the same is true if, you know, if a plan was filed in, you know, 1957 and we don't have it anymore, it's not our job to go to the registry to get it for them. If we have it, you know, kind of within our grasp, either electronically or paper, we need to produce it. If we don't need to find out where it is and acquire it.
Okay. Couple more quickly. Does COVID play into the timeframes of any of these records requests? Is anything affected by the pandemic, let's say?
So not officially, but I think the secretary is sympathetic. If you say, I need more time to produce these records, I'm only in the office once a week, or town hall is shut down, and you respond, either to the requester or the state with that information there, the state is sympathetic to say, yeah, okay, we're not gonna prosecute on this one. I will say though, the farther we get into this, the less sympathetic I think they're becoming.
Okay. And then finally, I've got a question from Chief Soros, who's on the call as well. The chief's question is, I thought if the requester is making the request for commercial purposes, it is not required to respond. That is to say, if I'm requested by a private citizen for the addresses and owners of all of the structure fires in the last year, and we find the private citizen is a contractor looking for work, we are not required to treat it as a public records request. To my knowledge, Tom, we can't ask why someone's asking for the information. Is that correct?
Right, but we are allowed to, and Ethan might be able to dig out a little more information on this one. Typically, we're not allowed to ask why the person wants the records, but I think if we sense it's for a commercial purpose, I think we can charge our actual fees. But Ethan, maybe you could dig into that one and report back.
Okay, and I guess lastly, another question about email records. If someone's using an email address for town business, are they responsible for keeping those records, or at some point can they transfer those emails to the town for record keeping purposes?
So I see no reason why they couldn't transfer them to the town if the town has the ability to hold them. And, I suppose you could give them to them on a disc.
Okay, that's all I've got for now, Tom.
Okay. All right. Okay, so now that's on to the open meeting law. And the open meeting law applies to public bodies, including subcommittees. And, remembering I'm on your side, people come up with a lot of different names for subcommittees, but it's still a subcommittee. If it is less than a quorum of a board doing the work of that board, it's a subcommittee and it's subject to the open meeting law. Okay, so educational requirements. So when you begin your municipal employment on whatever board or committee you serve, you will receive a copy of the open meeting law, copy of the AG's regulations, a copy of the open meeting law guide, and determinations issued to the member's public body within the last 5 years in which the AG found a violation. So, and I think the answer to that is 0 in Carlisle. But, if the fireworks committee got an open meeting law violation last year, any new member this year would have to get a copy of that AG's determination. Members must sign a new certificate upon re-election or reappointment to the public body. And that certificate says that you have those educational materials, and it could be an electronic format. Okay, the open meeting law. Basically, it boils down to this. Any deliberation of a public body must occur during a public meeting. So, and the real meat of this is what's a deliberation and what's a meeting. So let's get into it. A deliberation is an oral or written communication through any medium, including email, between or among a quorum of a public body on any public business within its jurisdiction. So, and emails are particularly troublesome, and I'll tell you why. So if three members of, so say we have a fireworks committee, and the sole business of the fireworks committee is fireworks on the 4th of July. That's all they do, but they do it really well, but it's all they do. So if it's a 5-member board, anytime they're talking about, anytime 3 or more of them are talking about fireworks, it needs to be done in an open meeting that has been properly noticed, with an agenda, and that you then will hold minutes. So if if a quorum of that fireworks committee is talking about the Red Sox, that's fine. It's not a matter within their jurisdiction, but anything fireworks related is within their jurisdiction and has to occur within an open meeting. And so to go back, why is email troublesome? So less than a quorum can talk about anything they want. It can be board business, it can be not board business. If 2 members of the fireworks subcommittee meet at Fern's and sit there all day talking about fireworks, that's fine because there's not a quorum of them present. But if they email each other, the state assumes that that email could be and likely would be forwarded. And once it goes to that 3rd member, we now have a deliberation because we have a quorum talking about or writing about the business of that board. So we want to be particularly careful with email. You think it's a private form of communication, but as soon as it gets forwarded, it's not anymore. Okay, what is not a deliberation? A subquorum, if not a subcommittee. So again, 2 members of a 5-member board can talk about anything they want. Board business, not board business, it doesn't matter. And the key here though is, if the fireworks committee created a subcommittee just to talk about sparklers, so now they're a subcommittee. So now those 2 have to post before they talk about sparklers. So you can talk about, and I think Alan asked this question, anything that involves any kind of communication that is either the distribution of meeting agenda, scheduling, or procedural information, you can email the whole board about that. That's okay. The state understands that that's the way we communicate, but make sure you just limit it to that kind of communication, that you're not getting into a deliberation. You can distribute reports or documents to be discussed so long as no opinion of a member of the public body is expressed. So if I write a report and I send it out to a quorum of my board, that's okay. If I write a report and send it out, but let me take that back. So say we have a report, I receive a report from someone and I want to share it. I can just send it on, that's fine. If I take that report and write on it, I think this stinks, this is not the way we want to go, put my opinions over it, and then share it, they now understand where I'm coming from with this report. And that's a violation of the open meeting law because the public was entitled to hear my opinion in open session without it happening outside of open session. Okay, so again, a deliberation is a quorum of a body talking about board business. So now if you think about it, the selectmen select board need to worry about this more than others because they have a lot more matters within their jurisdiction. The fireworks committee just does fireworks. Planning is planning. So, if planning starts talking about something that's not related to chapter 40 or chapter 41, which are our zoning and planning, they're probably okay. Okay, here's what sometimes is considered a meeting, but is not. So when you all gather, when the Conservation Commission, a quorum of them goes to do a site inspection, that's not a meeting. It doesn't need to be posted. Public's not allowed to attend. It's just an inspection. You can do, the whole commission can go together. The kind of watchword here is no deliberations. When you're out there, you observe, but you don't start writing the order of conditions with the other members while you're there. Attendance, okay, what else is not a meeting? Attendance by a quorum at an event provided no deliberations. So if there's a Halloween party and all 5 members of the selectmen are at the Halloween party, that's okay, just don't deliberate. And attendance by a quorum at a meeting of another public body provided no deliberations. So again, the zoning board wants to go watch the planning board's hearing, and it's, it's in the good old days, in the good future days when we all meet in the same room. That's okay. They don't need to post. The advice, however, is post. If your board, if a quorum of your board is going to another board's meeting, you want to post, because the deliberation can, you can deliberate without knowing. So for instance, if, zoning boards at planning, so they do have, a lot of crossover in their areas of jurisdiction, and one zoning board member offers an opinion, the other zoning board members hear it, offer another opinion, that would be considered a deliberation. So in that instance, better to post. Town meeting. The Secretary of State has told us that they do not prosecute violations of the open meeting law at town meeting, so that, if a board wants to gather at town meeting and discuss matters within their jurisdiction, you are allowed to do so. I believe the state feels that because it's difficult enough for a town to do its business and can only hold so many town meetings, they're not going to penalize a board for discussing matters within its jurisdiction at a town meeting. And it might be useful to the town to have the planning board consider what it thinks of an amendment to a zoning bylaw, even if they haven't posted. Okay, meeting notices. Any questions, Tim?
I've got a couple, Tom.
Are they, yeah, why don't we take them?
Okay, I've got one that says, if I write a report at the request of the board, may I include in it my recommendation and then send that report to the full board?
So, yeah, so in that instance, one member is tasked with writing a report. So that one member writes a report. We can assume that report contains that person's opinion. That report can be sent to the rest of the members of that board. The key is that those other board members should not respond. So sending the initial report, no problem. Receiving comments on it, a problem. We don't want to do that. You receive the report and you don't comment on it until you get to the meeting. There's, there are, this often comes up in the writing a decision arena. So I'll tell you, and is there a question about Google Docs yet?
Not yet.
Okay, well, I'm going to anticipate that there is going to be a question about Google Docs, and we'll just jump right into it. So I'm on the planning board and I'm writing a decision. They've come to the board for a special permit. I get assigned the task of writing the decision. So I write the decision. The law tells me that I am allowed to send that decision out to the other members. Each of those members can comment on that decision and send it back to me individually, not as a, not sharing with the group, just individually. So I get the comments of those 4 members. I can insert those comments, and then I can either then post that draft to the website and share it with the other 4 members, or share it with the other 4 members kind of immediately prior to our next meeting. And by immediately prior, that's like an hour or less. It's not a day. And this may sound a little cockamamie. I feel a little cockamamie offering the advice, but this is how the Supreme Judicial Court has told us to handle these situations. So ideally, you know, if I were the drafter, they say ideally it would go to a staff member to compile the comments and then post or share with the other board members. But if a staff member isn't available, which I know in Carlisle, not everyone has a staff member, then it can be an individual member. I know some boards are in the habit of using Google Docs. I am concerned with the use of Google Docs for the following reason. So that if I go on Google Docs and do a draft, and I'm on a 5-member board, member 2 and member 3 go on to review and also edit. Member 3 knows not only what I wrote, but what member 2 commented. And I believe the state would consider that a deliberation and an open meeting law violation. So I know how efficient Google Docs is and how it seems like the ideal tool for drafting decisions. But I will tell you that if you're using it and if someone files an open meeting law violation based upon your use of it, I'm not at all confident that I can defend that accusation successfully. So my advice is to, use Word docs and, send it out. One person gathers comments, and that's how far you can get in between meetings. Tim,
Okay.
any other questions, or should I go back to the slides?
I do, just one more, and I think it's a quick one. Can the secretary of a public body send out draft minutes and receive comments prior to the next public meeting?
Is the secretary a member of the board or is like a staff member?
I think it's a member of the board, if I read the question correctly.
Okay, so really the same rules apply. So the board member who is secretary takes minutes, distributes to the other board members, ideally individually or using BCC, can receive comments back from each member individually and insert those comments, and then either post that set of minutes to the website so that the public can see it too, and then the other members have access as soon as they want, or kind of wait to right before the meeting or at the meeting and share the minutes and comments.
Okay, and what if it's a staff member that's putting the minutes together? Does that change the analysis?
Not much. The staff member would send out, receive comments back, put the little that you often see, don't share with other board members, get comments back, and then either post to the web or share right before the meeting. And so let me just take a minute to say why I think it is not a problem at all to post draft documents to the website. And I think my experience is that sometimes board members get concerned that, well, these aren't approved minutes, so I don't, they might be wrong. I don't want to put them on the website if they're wrong. So first, draft minutes are public records. We can't protect draft minutes unless they're executive session minutes. So if someone requests draft minutes and they exist, we're required to produce them. Second, they don't really have any standing until the board accepts them. So we could have a draft set of minutes posted to the web that are wildly inaccurate, but it's just a draft. It doesn't mean anything. No, it can't be used in a litigation case that, that you said this in the minutes. Well, the board didn't say that. Maybe one member thought that, but a majority of the board approves those minutes, and they're not really anything until the majority of the board does approve them. They're just really one person's opinion of what happened. So I guess I would just not be concerned about that. That, if this helps you do your job, I would do it. So that's my rant on that. Any other questions, Tim?
Okay, actually, they keep dribbling in.
They're rolling in. We
What
got
about
10.
Yeah, what about using Google Drive just as a repository of information so that board members can have common access to maps, photos, reports, and so forth. There's no problem with that, is there?
There is no problem with that.
Okay, and then there's a question about, with respect to draft minutes, what if a reporter from the local newspaper asks to see the draft minutes? Now, do they have to be in draft form, or can simply notes be considered public record that needs to be turned over?
So draft minutes are a public record. Personal notes or notes used for your own kind of personal thought process on the board are not discoverable. So I think we need to differentiate, if you ask me for my notes, I may say, I'm not taking minutes. I'm just, kind of jotting down some thoughts, and they're more personal in nature than public in nature. And I think I would likely be allowed to maintain my privacy exemption on those notes. If they're more in the form of, I was assigned the minute taker, and I've kind of spelled them out, then they're clearly draft minutes and are subject to production. But I would caution whoever is requesting those draft minutes that they not rely on them, because they are not a reflection of what happened at that meeting based on a vote of the board.
Right.
So they don't really have much value in that regard.
But it needs to be a document. It needs to exist as a document in order to be.
It does. You
Considered.
you never need to create a document. So, if someone requests a spreadsheet of, the 17 permits that the planning board has issued in the last 2 years, if such a spreadsheet exists, we need to produce it. But if that spreadsheet does not exist, we do not need to create it.
Okay. Okay. All right. Another question that just came in the era of Zoom, where we can record meetings, would simply uploading a recording of the meeting obviate the need for written minutes, or do minutes still need to be produced?
I wish the answer to that was you can rely on the recorded, the video or audio recording of the meeting. And I've actually had a conversation, petitioning the state to consider that if we posted an audio or video recording and included timestamps to say, here's the agenda, the vote for this matter happened at this time and this matter happened at this time, but no one's taken me up on it, and we still need to produce written minutes.
Okay. All right, those are all the questions we have at the moment.
Okay. All right, so now we'll just, for you meeting notice drafters, remember we need to post our notices 48 hours prior to the meeting, excluding Saturdays, Sundays, and legal holidays. And we had a Monday holiday this week, and those are always the bugaboo. Someone always screws up on that one, but I'm confident Carlisle didn't. But that's the trap. In drafting our meeting notice, so key here, and again, it's about transparency. The quality of our agenda must be that it reasonably advises the public on the topics to be discussed. So, the category old business is not enough. You need to say what you're going to discuss in some level of detail. So, if it's, repaving of the rotary, then it's repaving of the rotary, but it can't just fall under old business. And I do watch, to tell you the truth, the agendas in Carlisle, and I think in general, they're pretty good. Okay, executive session. We need to identify that executive session will be held, and we need to include as much detail about the purpose without compromising the purpose for which it's called. So the classic example, so say we're looking to buy land. Say we're looking to, to buy 12 Washington Street. Well, if we can say this is the property we're looking at without kind of hurting our chances of purchasing it or purchasing it for the price that we think we can get it for, we should include that. If, however, we believe, if we let people know that we're looking at 12 Washington Street, the price is going to go up, then it's okay for us to exclude that. But that we should actually go through that that decision-making process as we're drafting. Can I include it, or will I be harmed if I don't? Okay, the date and time, oops, I jumped ahead. The date and time the meeting is posted must be recorded on or with the notice and logged in at the town clerk's office. Okay, so COVID-19. So what's going on now? And I know we've all been doing it for a year, but just as a quick refresher. So the state discontinued the public access requirement. So before COVID, the public needed to be able to attend the meeting. But since we're not having live in-person meetings, we now need to provide adequate and alternative means of access. And that can be a conference call. I know Zoom is probably how we do most of our things. It's Zoom. And so it can even be, directing them to the cable channel. The key here is that they need to be watching it almost live, so that, if there's a 20, 30-second delay, the state's okay with that, but they're not okay with the idea that we're going to meet and record the meeting and post it tomorrow. We would have to show an economic hardship in order to do that, and there is no town that has applied for that economic hardship that has received it yet. So, so the discontinued public access requirement, we just have to meet it with adequate alternative means. It obviously allows for remote participation of all members, and the body itself can meet in public and keep the general public remote, or everyone can meet remote. And I know there are a few boards and a few towns that have gone back to just the board meets in public, but by and large, it seems everyone's doing their business on Zoom. Okay, Zoom bombing. And I know we did have this problem early on, and I think we've solved it, but I guess, Tim, have we had any incidents of Zoom bombing in the?
Not for several months.
Okay, so we're
Yeah.
good there. So, and how did we go about solving it in Carlisle? Did we make people call up for a password?
Well, we asked people to email the general town hall email address, and we send the link out to them in a separate email. So I
Okay,
think that additional step made it unattractive to people that were interested in Zoom bombing, I guess, because it's worked pretty well.
okay, then that's a perfectly legal approach. I think the add-on to that is, if you're going to send a link, you're not going to put it on your agenda, you're going to send it upon request. You need to be able to respond to requests for the link during the meeting, so that if that's your process, and someone knows the meeting started at 7 and wants to email someone at 8:30 saying, can I have a link? I mean, I know you're not going to get it to them in 30 seconds, but someone needs to be keeping an eye on that email so that it can be sent back in due course. Okay, public access. So again, we've talked about how the public accesses the meeting. I think it's important to remember the public doesn't have the right to address the board unless the board wants to allow them to address the board, unless it's a hearing. So that if, if you're meeting and you're not, it's not a special permit hearing or a wetlands hearing, it's just, you're just discussing board business, the public has the right to observe. They do not have the right to participate. They participate only with permission of the board. Okay, so just a quick second about minutes. So minutes must include the date, time, place, and members present. And again, and I think Carlisle's good about this, but when you're doing your Zoom meetings, you always want to start out with, acknowledging that the meeting is being held remotely, and you want to introduce the members, if you can see Kate or Alan's Zoom box, you note that they have their name and their title, Select Board. So, and I would encourage every, planning board, zoning board, whatever board you are, should do the same thing, just to help the public understand who the board members are. Okay, back to minutes. So date, time, place, and members present. Sufficient detail to reasonably advise individuals not at the meeting of what transpired. So, there's 1,000 shades of gray here, but if you have a 30-minute discussion on a particular topic, I do not think your minutes need to be, kind of a verbatim dialogue of everything that was said. Nor do I think you can cover that in 2 sentences. So you want to be, you want to take a good paragraph just to describe. I mean, if you talk to something for 30 minutes, you can probably come up with a paragraph on the tenor of the discussion. And you always want to include decisions made and action taken and record each vote. So, how members voted and what the 5041, whatever it is. Any documents that you reviewed at the meeting should also be listed in the minutes. They don't need to be attached, but if you're looking at a certain document, there should be a last page that says these are the documents we looked at the meeting. In the minutes, you always want to identify those members participating remotely. And since we're in the remote process, we're doing roll call votes. Excuse me. The open session minutes will always have the motion to go into executive session and the roll call vote to go into executive session. And finally, we want to approve those meeting minutes in a timely fashion, because again, we can get in trouble if we don't. So timely manner is considered to be within the next 3 public meetings or within 30 days, whichever is later. So that if I'm, fireworks committee meets 4 times a year, so their minutes are going to take a while, but select board meets every week sometimes, so their minutes are going to come a little faster. So, for you boards meeting kind of 3 times a month-ish, you want to be getting those meeting minutes out on a monthly basis. Okay, here's just a little trap that some of our serial requesters try to catch us on, but a request for meeting minutes has to be responded to in 10 calendar days. So you receive a records request for minutes, it's calendar days. For all other documents, it's business days. Why they did that to us, I have no idea. To me, it's poor drafting and just leads to confusion, but the law exists and you need to be aware of it. Okay, I'm going to go just talk quickly about executive session, and this is kind of our wind down, but any other questions, Tim?
Yes, we did have one that came in. At a public meeting, is the meeting host allowed to ask for the name and address or email address of members of the public who are attending the meeting but are not participating in the discussion? So can the chair, I guess, ask people to identify themselves if they are attending but not participating in the meeting?
So this question actually came in shortly before this session began. I believe the answer is, you cannot, if someone wants to participate, we can absolutely ask for their name and address. If they're not participating, they're just observing, I do not believe we're allowed to ask for their name or address. I will send a correction out if I'm wrong, but I don't think I am.
Okay, thank you.
Okay. So executive session. It's more a thing of certain boards probably do a lot more executive session than others. And we tend to talk about it when they're doing it. So I'm gonna go through this on the quicker side. But if you have any questions, again, please, let's talk about it. Okay, so here are kind of the keys to executive session. First, we have to convene an open session. So one of the classic traps is we're just meeting for executive session, so we don't even need to open the meeting. Wrong. You absolutely have to open the meeting. You're going to start an open session. I call this meeting to order. Is there a motion to go into executive session? The executive session motion is read. We have our roll call vote. We include in the motion that the board will be coming out of executive session only for the purpose of adjourning, so that other people can go home and not hang around. Then we can then go into executive session. But don't just go into executive session, because that is an open meeting law violation. Okay, so executive session is just for the members of that board. So if you want to invite anyone else in, town council, Tim Goddard, you should include that in your motion. Sometimes the chair needs to make a declaration that talking about whatever you're going to talk about, there would be a negative effect on the matter if it was talked about in open session. And so the chair needs to make that declaration, and it's for purposes 3, 6, and 8. And we can talk about that a little more, but again, I think Carlisle's good about that, but it's just another thing we need to tick the box. We talked about specify whether the public body will return to open session for any other reason besides adjourning. So if you're going to go back to your regular business, you want to let the public know. And if you're not, you want to let the public know too. And then the roll call vote is taken. Okay, executive session minutes are like regular session minutes. They must be reviewed in a timely manner. So the same rule applies, kind of the 30 days or 3 meetings. They may be reviewed in open or executive session. And this, to me, this is important and I think very helpful, is the board may designate a single reviewer to approve the minutes and to determine whether the executive session purpose still warrants confidentiality. So we have our executive session minutes, and they are not subject to production as long as the purpose is still alive. So if we went in to executive session to discuss the purchase of 12 Washington Street, and then we purchased 12 Washington Street, it's very likely that those minutes are now subject to release. We purchased it. No one needs to know about our purchase strategy anymore because that ship has sailed. So you then need to release the minutes. And so the kind of the good practice is 4 times a year, just think about your executive session minutes and which ones might be subject to release. And if you take this additional step and say, you know what, the chair can decide when those minutes are subject to release, we don't need to vote on it. You can then, it then happens, and you don't get caught in the trap of going into executive session to decide whether or not minutes are subject for release, and then having to draft minutes for that meeting when it was a 2-second meeting. This is a newer option that they've given us, and I'm all in favor of it. I think it saves a lot of time. Okay. So purpose one is to discuss the reputation, character, physical condition, or mental health, rather than professional competence of an individual, or to discuss the discipline or dismissal of complaints or charges brought against a public officer, employee, or staff member or individual. Okay, so this is, we use this one for sensitive topics, but for you boards that are in charge of evaluating your staff members, you don't get to do it here because it's not for professional competence. So you can't go into executive session to talk about your staff members, poor performance. You need to do that in open session. And I know it's an awkward conversation, but we really have no choice. Two is to conduct strategy sessions and preparations for negotiations with non-union personnel, or to conduct collective bargaining sessions or contract negotiations with non-union personnel. So this is mostly a select board matter. Purpose three is to discuss strategy with respect to collective bargaining or litigation if an open meeting may have a detrimental effect on the bargaining or litigation position and the chair so declares. Okay, so we talked about this, but this is one of those purposes where we need the chair to declare. So, if we're meeting, the zoning board's in a lawsuit and we're meeting with them to discuss the litigation, the chair's going to want to say, I declare that discussing this matter in open session would have a detrimental effect on our litigation position. Okay, four is the discussion to discuss the deployment of security personnel or devices or strategies with respect thereto. Kind of a school committee selectman issue. To investigate charges of criminal misconduct or to consider the filing of criminal complaints. So, any board may become aware of a staff member who, they suspect of criminal misconduct. So this is, any board could have this one, but I hope you never have to use it. 6 is the land. So to discuss the purchase, exchange, lease, or value of real property. Again, if the chair declares that an open meeting may have a detrimental effect on the negotiating position of the public body. Chair must declare. And, consider identifying the property and consider whether or not that might have a detrimental effect on your negotiating position, and then don't include it if you think it will. To comply with or act under the authority of any general or special law or federal grant in aid requirements. So, this one is not used often. I will say that when reviewing executive session minutes, so if you have executive session minutes for litigation that you want to review, you can use purpose 7 to review those executive session minutes. The preliminary screening committee. Okay, so you can use executive session to consider or interview applicants for employment or appointment by a preliminary screening committee if the chair declares that an open meeting will have a detrimental effect in obtaining qualified applicants. Okay, so many of you may have to deal with this, so let's just take a second. So the first thing is, so let's say it's the planning board that's doing the hiring, and so the first thing is they can create a preliminary screening committee for a new town planner, but a quorum of the board can't sit on that preliminary screening committee. So less than a quorum, yes. A quorum, no. Okay, so now that so they've created their preliminary screening committee, so they can, so you kind of need to figure out your numbers. So I always assume that, they need to, the final interviews, really, it can't be one person. A preliminary screening committee can't just select one member to go to the big committee for interview. It really needs to be 2 or more. 2 we can get away with. 1, if someone were to challenge us on that, I don't think we could defend it successfully. So the preliminary screening committee, you have 6 applicants for town planners. If that preliminary screening committee can reduce that number to 2 or 3, and then hand those 2 or 3 over to the whole board for consideration. And I would actually encourage you to use this, this purpose, because, you know, sometimes you're going to get more and better applicants if they think they're doing it confidentially. So that, you know, if you know, the planner from Stockbridge may not want his board to know that he's looking for another job. And, you know, he may not want to go into a process if he doesn't know he's a finalist. So again, I think it's a good process, and I think it's a good process in hiring. And I encourage you to use it if you see the opportunity. Purpose 9 is for a mediator, rarely used. Purpose 10 is to discuss trade secrets or confidential, proprietary, or competitively sensitive information related to acting as an energy supplier or in relation to other entities selling electric power. Again, rarely used. Okay, so the final part, and then, you know, any questions you want to ask, is we all make mistakes. So if you do, the best thing to do, let Tim know, let us know, we can help. If you identify the violation and you go to fix it, you know, you're going to get a gold star from the state. You're not going to get a reprimand. It's the hiding it, it's the ignoring it that gets you in trouble. It's kind of the classic, you know, it's not the violation, it's the actions you took after the violations to maybe hide the violation. That's where you get in trouble. So they don't expect us to be perfect, but they expect us to correct our mistakes when we identify them. And, you know, and if you failed to post a meeting, and, you know, you do the meeting and oh my God, we never posted it. Well, then we'll just, we're going to let the state know, we're going to let the town know, and we'll retake whatever votes we took and try to give everyone a flavor of what we discussed, and maybe even hold the discussion again. So again, as long as we can let the public know that we didn't purposely do something in private, and that we'll let them know what we did, we should be fine. So don't be worried about a violation. Let's just correct it and move on. It's simple to correct. You're going to get a pat on the back, and you know, away we go. That concludes the presentation, but I'm here as long as you want me to answer any additional questions you have.
One question I had, Tom, when you're doing executive session, the identification of the individual who may be involved, is that appropriate?
You need to consider it. So ideally, yes, you want to include the name of that individual involved.
Okay, thank you.
If you have if there's a kind of a compelling reason not to use their name, you know, because of a mental illness or something like that, we can talk about a way around it. But the default is yes, you should include the name.
Thank you.
Okay, Tom, I've got a question here from Bob Zog. Maybe I'll ask Bob to unmute and ask his question.
Okay, and I'm going to stop sharing this screen so I can see.
Okay.
Yes, thanks, Tim. So I had heard that the minimum for a quorum is 3 people. In other words, we cannot have a public body that has fewer than 3 members. But I also learned recently, and you reinforced this, that sometimes 2 members who are meeting on a regular basis can be considered a subcommittee and subject to all the requirements of open meeting law. That seems inconsistent with the requirement for 3 as a quorum. Is that requirement of 3 correct?
Not that I am aware of, Bob. I'm not aware that there is any requirement of 3 as a quorum. And I would say the kind of the proof there is that I know one person cannot constitute a subcommittee, but 2 people can. And so I would say a quorum can never be less than 2 because 2-member boards can exist and then the quorum is 2.
Okay, so technically speaking, public body could be just 2 people. That's acceptable.
It could.
Okay, thank you.
I don't think it's a good idea to design a board that has 2 members, but it could be, particularly if it's a 3-member board and there's 1 seat vacant.
Right.
So Tom, how do you actually make that subcommittee? So I support the Historic Commission. We're
Mhm.
just about done with this situation, but we've been working on a district map and 2 of the members have been working very closely on that. But we are a 5-member board.
Right.
Was it okay for those 2 to be together working on that without posting and really officially making a subcommittee?
So ideally they would, if the district map is likely a matter within their jurisdiction.
Right, yeah.
I don't know how the task was assigned to them, but it's likely that the better reading there is that they're a subcommittee. And I can tell you, so the kind of, if you think about it this way, only a public body can create a subcommittee. So, and I'm not offering this as a workaround, but I think the open meeting law likes the idea of daytime government doing the work and nighttime government in more of a strategy policy role. And I know that's not always possible, particularly in a small town, but if the committee had asked you to prepare that map, you cannot create a subcommittee. So if you sought the assistance of whoever you thought could help you, have one member look at it or another member look at it, that would not be, you would not have created a subcommittee because you can't create a subcommittee and that it was delegated to you individually. Does that make sense?
Well, yes, that makes sense, but I guess and we're at the end of this anyways, but it was a CPC project, town gave funds, and then 2 board members were assigned to work with the individual that won the bid to do the district map.
Yeah.
So the
Well, so
commission
what
did
did they-
take a vote to put these 2 people on this, charge. But I don't think we've really ever considered it a subcommittee because it's
Yeah.
only two guys and our quorums is 3. I don't know.
Yeah, it's so wait, your quorum is, how many members? Your quorum is 3. Yeah,
We're 5, yeah.
right. So if someone challenged that, I'm not sure I would win,
Okay.
but I
Well,
try.
It's almost done, so we're owning up to it. We're sorry.
Yep.
And then
Okay.
real quick on Zoom, and I actually sit on a board in my hometown. We're not allowed to use chat. Is that just our town, the town I reside in, or is that really a open meeting law violation to use chat during a meeting?
So it's an interesting question, and we don't, as far as I know, we don't have any guidance on chat.
Okay.
So what I will say is, if board members are using, if the public's using chat, I don't care. They're not part of my board.
Okay.
If board members are participating in the chat, then we should be saving those chats. And maybe making them part of the minutes.
More work.
I'll just add, Tom, that Zoom does save the chat transcript for you.
Oh, there you go.
So it's if someone wanted to know what comments were made during the meeting by which members, they could fully find that out. So
Good, okay.
words to the wise. Tom, I had a request. If you could repeat the answer you gave to Alan Lewis's question. There's a couple of questions ago, but
What was the question?
got it. Well done.
sorry.
Hi, it's Madeline. What I missed was the question. The answer was that you should mention someone's name, but I missed the question.
So that was purpose. I think he was asking about purpose one, when you're going to discuss the mental health, physical condition of an individual, employee, or public official. So if you're going to do that, there's a whole process that goes along with that. It needs to go on the agenda. And I think Alan's question was, if we're doing that, do we need to use the person's name in the agenda? And the answer to that is yes, ideally. And I said there are certain times when I think we could successfully not use the name, particularly if it's, a mental health issue that you want to discuss, and clearly the person's privacy trumps the public's right to know that you want to talk to them about it. And so in that case, I might encourage you not to use it, but in general, I think you need to use the person's name. And to add to that, you're also going to give that person 48 hours notice that they're going to be discussed. They have access to the meeting. They can bring an attorney. You don't have to let the attorney speak, but the attorney can be there. And finally, and kind of the big kicker is, if they choose to have that discussion in open session, you need to comply. So it's going to be, if you want to talk about me, not my competence, but those other things, you need to send me a notice that you're going to talk about me 48 hours ahead of time. I have the right to bring an attorney, and I have the right to say, no, I'd prefer you have that discussion in open session. And then you need to have it in open session.
Okay, other questions?
I have a question, maybe it's a comment about the chat function. I think the board members absolutely should not be chatting to one another in the chat function. That's tantamount to having whispered conversations at the, at an open, in-person meeting. And secondly, in terms of, inviting chat questions, I think that's also can be problematic. I've had experience now with the Zoom where the chat on the side becomes a distraction to the people, to the board members, because, it's individuals, maybe, being in fact rude to one another in the chat. So I'm wondering if maybe we should be, the select board should be considering a general policy about chat at Zoom meetings, so that to give guidance to our boards and committees.
I think that's good advice.
Okay, so put that on our agenda, Alan.
All right.
Put that on your agenda.
There you go. We got another question from Jeannie Janesco. Jeannie, could you unmute and ask your question? I don't want to get it wrong. It's a little involved, but.
Okay, yes, I'm Jeannie Janetsko, and I just had a general question about, I'm a member of the public and I go to a lot of meetings, and if I think that open meeting law is being broken, not that it's deliberately being broken, but that I think that since open meeting law is complicated and it is being broken, can I go to the town, let's say the select board, or to the town administrator and express my concern? If I express my concern, am I entitled to an answer? Because the goal is not to take the concern to the state. The goal is just to get a clarification so that the committee can be asked not to break open meeting law. That's it. Am I
So-
clear?
I think I understand that. Yes. So, I think you're always welcome to go to the town administrator and voice your concern. And I suspect that the town administrator will, kind of consider your question and provide you with a response. But technically, you're not entitled to a response. And going back to the whole public records component, you're entitled to documents that you request. So if you ask for documents, we need to provide them if we have them, but we are not required to answer questions. It might not be in our best interest to avoid those questions, and it might be the right thing to do to answer those questions, and I suspect we would answer them, but you're not legally entitled to answers. Does that make sense?
That makes sense, but it leaves me in a bind, because if I feel open meeting law is being violated, then it almost, am I supposed to just ignore it if I go to a meetings if it's continued? Or, I mean, what is my path at that point?
Well, I don't think anyone's asking you to ignore it. I think the question you asked is, can you report it to the town administrator? And I would encourage you to do so. Of course, you can report it to the town administrator. And I think if he sees the need to take corrective measures, he could take corrective measures. But I don't want to mislead you and think that, because you complained to the town administrator, he is now going to write you a letter detailing what he did. He doesn't have to do that, and you can't require it. You can request it. So you're in a position to request, but not require. And of course, if you're dissatisfied with a response, you can go to the state and file a complaint under the open meeting law.
I understand what you're saying. It just seems like it's the question is just, I mean, I'm not questioning your answer. I understand your answer. It just seems like it would be just easiest to get an answer, because yes, it was being, I'm assuming it would go to you if they did not understand, or if they did not know if it was an open meeting law violation. And well, it's too confusing. I guess I'm just disappointed that I can't get a verbal so that I can go back to the committee and say, you are not obeying or following the open meeting law. So you don't need to explain anymore. Thank you.
Okay.
Any other questions? I don't see
Ethan,
anyone-
any light breaking news on your end?
So a couple of things you asked me to follow up on, Tom. One of them being whether or not you can ask an individual for their name if they are present at a public meeting but not speaking. I think your answer was correct. The only caveat I would have to that is that you can be required to give your name if it is required to enter the building in which the meeting is being held. That happens in a couple of occasions, depending on where the meetings are held. Otherwise, you were correct. You're not required.
Okay.
Adding to that, Tom, can't the board, for the record, have, list the name of everyone who attended a public hearing? Or I think that might be at the root of the question. You want to have an accurate record of who attended, and if someone's not using their real name, or
Or chooses not to sign. Yeah. So
Yeah.
So right. So we're in the downstairs hearing room, and we hand around the sign-in sheet, and someone either uses a false name or doesn't sign it. And the chair says, "You didn't sign this." So if the chair wanted to eject that person from the meeting, I would say I'm concerned I couldn't defend that. I think the person has the right to not sign the sign-in sheet. If that person wants to speak and won't give their name and address, I would not recognize them.
Okay. All right.
And then, Tom, does that also apply if it's a Zoom meeting?
Yeah.
And let's say the person has a false name up, or, you can't ask them to identify themselves.
Right.
Okay.
Is there any chance that the state will come into the 20th century with this 48-hour posting requirement since, you know, you could post it on, you know, the chair of the committee could post it online, it could have a timestamp on it, and it could be 48, but if, you know, if you can only post it during the hours that the
Yeah,
clerk isn't thing, sometimes that's like 78 hours.
I know.
Um,
I'm sympathetic, you know, particularly in smaller towns, but no, they're, honestly, they're going the other way.
Ugh. Okay. That will discourage anybody from ever wanting to be the chair of anything, you know?
Or you just post a meeting every week and then cancel the ones you don't have.
Well, yeah, but you have to post the agenda with it. And so just a blank agenda and then just update the agenda, you know, it's just,
I know,
it's
I know.
onerous. And
I
I mean, and then it becomes onerous for the clerk.
I know, I don't have a good, I wish I had a better solution.
Okay.
Anyone else?
Just a very, very useful and informative session. Thank you so much, Tom.
You're welcome, my pleasure. Good to see you all.
Thank you, Tom.
Okay,
Good.
bye, everybody.
Bye.
Good night,
Good
everyone.
evening.
Good night.
Good night.